Honourable Member Andrew Little.
Thank you, Mr Chairman. I am pleased to take a call in this part of the proceedings on the Victims' Orders Against Violent Offenders Bill, and begin by saying that in a week in which the nation has had its attention drawn to the horrific reality of domestic violence and sexual violence, then for this House, finding solutions, real solutions, long-term solutions, should be front and centre of what we do right now. And as my colleague Phil Goff has said, and indeed Carol Beaumont as well, while this bill goes some of the way and provides a solution of sorts to the problem that this nation has, dreadful problem, the embarrassing, shameful problem this nation has, it is still a half-hearted effort. More could be done. And I'm going to come to two particular provisions and to illustrate what I think the remaining problems are with this bill. Carol Beaumont talked about the fact that this bill still requires the victim to take the initiative. It is a civil proceeding that the victim must initiate. And for impecunious victims, getting access to legal aid so they can make an application of this nature has got a lot harder under this government. It is just harder to get legal aid. And in the budget that has just been handed down, this government, under this Minister of Justice, has put up this outrageous proposition where legal aid is cut by another $12 million, $5 million out of civil legal aid alone, and somehow now with this legislation, when this legislation is passed, we are going to have, the people who are looking to it for protection are somehow going to have to find the means to make the applications to court. And the reality is that for most of them, they will have to do it off their own bat, and they will have to represent themselves because getting legal aid will be too hard, and for many they simply won't be able to afford a lawyer. And so that gap remains, and I expect that that gap will get only ever larger. This bill also, and the orders that it creates, the two types of orders, the temporary non-contact order, which happens or is granted on a without notice application, and then the final non-contact order that is granted or at least processed on notice and is granted after a hearing. But either of them will require adequate and sufficient resources to be available in the registries of our courts up and down the country. And the reality is, after the shameful act of cutting our legal aid, the next most shameful thing that this government has done under this Minister of Justice and her Associate Minister of Courts is to gut the court registries of this country, put huge pressure on the remaining staff who are there to process applications, and that pressure is only ever going to grow under pieces of legislation like this. And I frankly despair, Mr Chairman, at the thought and the prospect of victims of violent offending, violent sexual offending, domestic violence, when they are able to collect themselves and process what has happened to them and start to take control of their lives, then have to go through this process, most likely at their own expense, and dealing with court registry staff who are under so much pressure and probably unlikely to give them a lot of help. That is the justice system that we are developing under this government, and it is shameful. And we have a Minister of Justice who's happy to swan around London and mince around with Angelina Jolie and photobomb Brad Pitt and talk longingly about protecting the victims of sexual violence in war zones, but she can't do enough for the good citizens of New Zealand and those who are in the unfortunate position of being victims of that sort of offending back here. Well, we deserve better. Mr Chairman, the people of New Zealand deserve better. I want to talk just about a couple of provisions here, because my colleagues Phil Goff and Carol Beaumont have talked about the bill. I want to talk about, first of all, just to point out that in Clause 15, the discharge of non-contact orders on application, and that allows an application for discharge to be made by a person against whom an order is made, which could be the offender or an associate. According to the bill, Mr Chairman.
The Honourable Member, Andrew Little.
Mr Chair, according to the bill, Mr Chairman, at any time, an application for discharge can be made at any time. So no sooner as an order has issued from the court, with the victim having taken the initiative and gone to their own expense and negotiated and navigated their way through an under-resourced court registry, an order is issued, and then the offender against whom the order is made can at any time apply for a discharge. There's no constraint on that at all, no limitation on the offender, no requirement that the order is in place for a limited period of time. And you would have thought that at least for orders made on notice where there has been a hearing and the court has heard from the offender, or at least the subject of the order, there must surely be a minimum time for the order to apply before an application for discharge can be made. But that provision opens it up for the offender to harass the victim in other ways by applying for the discharge. And then I'm going to turn to clause 15B that allows the offender, of course, once an application has been made, to require a hearing to take place. Now, in terms of principles of justice, don't have a problem with that. Don't have a problem with that. But where I am concerned is then now where the registrar of the court then takes a number of responsibilities. And the registrar has to, can take the application for a hearing, set it down, and the subsequent subsequent clauses in the bill, it is the registrar who can take the responsibility for explaining the impact and the consequences of one of these orders to a person against whom an order is made. And I go back to my point before, Mr Chairman, the resources of our court registries, particularly the district court, where these applications will be made, are stretched beyond belief right now. The court registry staff are just absolutely under the hammer. And you've only got to talk to some of them to find out that that pressure is unrelenting, because this government has said, we must squeeze more out of you. You must work harder. And we've got court registry staff not just working late on weekdays, but now coming in on weekends just to catch up with the work they're doing, particularly in relation to civil applications, because they are often the most complex ones to process and to work out who has to be served with what has to go to which court official and all the rest of it. The court registry staff in this country are under unreasonable and unremitting pressure because of this government. And when this bill gets passed, they will be under even greater pressure, and they will be required to deal with distressed people. And it is just unreasonable. And Mr King may think it's funny. Mr King may think that we should cut short this discussion and this debate on this very important issue. Maybe the National Party really just doesn't care about the victims of this sort of abuse and the importance of these sorts of orders. Because to look at them and to hear the Minister and look at her actions, which frankly speak louder than words, then you'd think they don't frankly give a toss. They don't give a toss. And that is why we have this bill in this form. Now, I want to echo my colleague Phil Goff's comments that it is well timed, well overdue for this country to have a comprehensive piece of victims legislation setting out rights and allowing victims to look to the state to afford them the protection that the criminal justice ought properly to offer them. It is not enough. It is not enough to rely on victims to take the initiative in their distressed state to protect themselves. That's what this bill does, and it's time we had a new set of principles that victims can look to the state and the courts to provide them with proper protection at all stages of the criminal justice system. And there is no reason in principle why the orders that are contemplated in this bill could not be part of either the sentencing process or the parole process, and so that the victim does not have to take the burden of that responsibility on them yet again. So, Mr Chairman, as my colleagues have said, we will support this bill because, as is often the case, something is better than nothing, but the people of this country are fast demanding something a lot better. And it is the Labor Party in government that will deliver it, because this government has shown in 6 years that it is not up to the task, it really doesn't care about victims, and it is not doing enough.
The question is that the Minister's typescript amendments inserting new clause 13A and amending clauses 14 and 20 be agreed to. Those of that opinion will please say aye. Aye. The contrary, no. The ayes have it. The question now is that part 2 is amended stand part. All those in favour please say aye. Aye. The contrary, no. The ayes have it. The question now is, honourable members, that clauses 1 and 2 stand part. I call the Honourable Phil Goff.
Mr Chairman, this bill is entitled the Victims' Orders Against Violent Offenders Bill, and the reason that we have it before the House tonight is because there is currently in place no law